So good morning, good afternoon, good evening, wherever you are, and welcome to the Modern Law Review Seminar on Emerging Technologies, Personality Laws, and the Dead. The team present here, Remy, Uta, Lillian, Marissa, Holly, and I are really excited to host this very interdisciplinary and excellent seminar that is supported by the Modern Law Review. And the Modern Law Review for lawyers means a lot, and I know for colleagues from other disciplines it might not say a lot of things, but for us it's one of the best journals, journalist journals in the field, and it's an honor, and it's a sort of considered a 4-star journal to publish it. And the mission of MLR is to deal with the law as it functions in society. So what we are doing here and what we are discussing is really relevant for the remit as well, because MLR is not your traditional black letter doctrinal law journal. So these kind of discussions are really valuable. And I think this is probably one of the most, if not the most interdisciplinary seminar that the MLR has funded. With the colleagues coming from, and I'll just name a few, obviously law, but then ethics, philosophy, sociology, human-computer interaction, design, philosophy, criminology, psychology, media studies, and if I've forgotten someone, I apologize. Politics, perhaps I've forgotten. So it's a shame that we're not face-to-face and that we can't take you out for dinner. So I apologize. And we had some ideas to compensate and for that, but the MLR wasn't very sympathetic. So I owe you all at least a drink at some point in time when we meet face-to-face. So please remind me if I forget. So I would like to thank you also for your videos and for your work before the seminar. I watched them all. I made about 10 pages of notes, and there's so many common themes, and I'm really excited for the discussions to kick off. We are missing some people that were on the list. Unfortunately, John Troyer, for example, couldn't make it because of illness in his family, and Megan Yip as well couldn't make it for personal reasons, etc. But most colleagues have fortunately joined. So we do have 4 sessions as you know, and they all last for an hour and a half, and we're hoping to be able to just have rich discussions, exchange the ideas. So I know the format is perhaps a little bit unusual. So our aim was not to have people just giving out papers for 20 minutes and receiving 3 minutes of comments, but really to have this rich discussion that is based on our positions expressed in the videos. And I think there is so much that we can learn from each other and where we can build for perhaps future projects, future papers, etc. And if I could just now write a research bit with all of you included, I think that would be the best research bit in the field. And maybe that's also something that we can consider at some point in the future. So there are half-an-hour breaks built between the sessions, and I thought they should be offline because we might want to just switch off and do our emails or have coffee and just not watch the screen the whole time. So I hope that's fine with you. And also, of course, the meeting will be on for the whole day. I won't end the meeting in between either. So you're free to pop in and out, of course, as you wish and according to your other commitments. There are chairs who kindly accepted to chair each of the session, and you will see they will introduce themselves, and I will introduce the first chairs as well. And I thank them for their work and the coordination to just facilitate and moderate the sessions. So before we start, yes, there's only one bit of history that I wanted to mention here as well. And I know Elaine is not here, but Lillian is and Burkhard is. Almost 10 years ago in Amsterdam Privacy Conference, 2012, I think, we had an interdisciplinary panel on postmortem privacy as well. And it resulted in special edition of Scripted journal on the issue. And it was, again, genuinely interdisciplinary. Elaine Casket was part of it, and Wendy Muncour and others. So I think it's good to remember a part of the history and where we are now with our continuing discussions. So in terms of just my final little point from me on the position paper that we circulated in advance, drafted by the team, and obviously it's very brief given the topics that it covers, but I hope you found it useful, and I know that some of you referred to the position paper in your videos as well, and I thank you for that. So I will just briefly recap the issues that were sort of mentioned, not covered in detail, but mentioned there. So we talked about historical arguments against postmortem privacy, and we looked at one of the concepts that I wish we'll explore further in more detail in all the sessions, which is harm to the deceased and other forms of harm. Then we also talked about the doctrinal and black letter law positions historically, and then we looked at some of the societal reasons for change in this area, including contractual issues around access and control to personal data and digital assets and digital remains more generally, and then the issues around autonomy and informational body as some of the examples. We also try to look at the issues that may support retaining the traditional concept of postmortem privacy, again, looking at harm, conflicts of interest, and balancing different interests that are involved in this area, and that many of you have really articulately noted in your videos. Obviously, the question of free speech and historical records. Then we also looked at the impact of technologies on digital privacy and the dead and individual and collective memories, which is the topic of our second session in particular, with looking at some dominant privacy traditions of Western thought, common versus civil law, and alternative approach to post-mortem privacy that would include dignity and memory production. So framing a privacy discussion in terms of memory, post-mortem privacy discussion in terms of memory and memories. And again, some of you have also referred to this in your videos. Then we looked at the emerging law and technology for the protection of postmortem personality and privacy. That is the topic of the final session, looking at some of the new laws and some of the emerging jurisprudence in the US that protects familiar privacy interests, for example. Then we looked at medical confidentiality that extends postmortem, and proposed some ways forward in the area of harmonizing data protection, looking at relational postmortem privacy and familial interest in the jurisprudence of the European courts, and then reframing the discussion in this area further. So just a very quick brief summary. I hope some of you had a chance to read the paper, and I won't be talking anymore. I'll just pass on to your chairs today, Michael Bernhardt from Tel Aviv University and Lillian Edwards from Newcastle University, and the project part of the team on this project. And yes, they will introduce the first session kindly, and I thank you for accepting to chair the session and for your work in advance of the session.